Here is the flag showing. Join it. Take it to the seat. We have to discuss this logistic tomorrow. Lecture. Okay. I want in the future, if Dina or I or anybody, we have Elena puts a mechanism like this that it's the gift.
Good morning. Good morning. Good morning.
Camera off.
Are we live? Can they hear us or not? احنا we're live. AC higher.
هلا مبدئيا هدول اللي عدتهم واحد في اثنين انه بدنا نعيدهم من تبع الفينولك تقريبا كان هون.
طلعت ايه؟
هي
طيب طلعت زي دي.
واحدة منهم طلعت مثلا.
طلعت زي دي. حلوة اهي. 0.137 0.137.
بس انا ما في تحسي غلط هون.
دكتور Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum everyone. On behalf of Dubai Pharmacy College for Girls, the first pharmacy institute in Gulf region, I am pleased to welcome all the audience, and I'm pleased to welcome the speakers, Ms. Dina and Mr. Firas from Noura Al-Mazmi Advocate and Legal Consultancy to give us a very useful presentation about intellectual property rights. I believe that it will be very useful for all of the audience, inshallah. My colleague, Ms. Yasmin, will be the co-moderator for the event today. So, Ms. Yasmin, please go ahead. Thank you.
Thank you so much, Dr. Hanan. It's my pleasure actually to be here today. First of all, I'd like to introduce myself. My name is Yasmin. I'm a research assistant at Dubai Pharmacy College. It's my pleasure to welcome you all today to this exciting webinar hosted by Dubai Pharmacy College. Before we move on, I'd like to welcome our speakers, Mr. Firas and Mrs. Dina. Our first speaker is going to be Mr. Firas. He has 17 years experience of alternative investment experience prior to joining Noura Al-Mazmi. He held several leadership positions with local and regional investment houses. Over the years, he has managed and set up private equity funds in real estate, education, and manufacturing, comprising over 65 assets across the following main markets of the USA, India, KSA, UAE, Oman, and Singapore. Mrs. Dina, our second speaker, she's an IP expert with more than 10 years of experience in the IP field. She received her master's degree from the International IP Law School in Italy in cooperation with the WIPO. Dina is a certified trainer in the field of intellectual property from the World Intellectual Property Organization. She participated as an expert in many training courses, workshops, and conferences in the MENA region. She was a lecturer for the diploma students in the intellectual property, and she is a tutor in the WIPO. Today's session, I hope it inspires and engages you. I wish you a happy time, and I hope it provokes your thoughts and everything. So, mics to Mr. Firas, our first speaker.
Thank you. Good morning, ladies and gentlemen, and thank you, Dr. Hanan, and everybody with regard to the lovely introduction. We highly appreciate it. And we look forward, of course, for this first session to be very fruitful for all the participants here, because our main objective here is to shed light on the untapped market of intellectual property. And it's very vital for all the grad students, along with all the personnel at the Dubai College, to be very familiar with the IP rights. So we'll start our presentation by sharing our screen to go through the agenda and what our presentation will entail. Just confirm if you can see the screen. So the agenda for today's presentation will be the introduction of intellectual property rights and how universities, such as yourselves and colleges, can benefit from intellectual property rights. Secondly, we will be discussing the introduction to industrial designs and trademark. Third will be types of works that can be protected by copyright. Fourth on the agenda will be types of inventions that can be patented in pharmaceutical field, which is going to be focused on your areas of expertise as a college. Fifth will be best practice to apply for a patent application. So we'll go into the nitty-gritty details on how we can basically do the work from a technical side. And of course, above all, for any institution, whether a college, a company, or an entrepreneur, such as potentially the grad students, when they go off to the basically the work field, the importance of having an IP strategies and policies for them. Okay. So basically, in the world of finance, in the world of accounting, in the world of how we can classify assets, there's two types of assets: the tangible assets and intangible assets. The tangible assets basically are what we're familiar with, what we see basically, such as hardware, property, buildings, furniture, land. These are all categorized as tangible assets across, you know, the books of basically companies, institutions, and so forth. So tangible basically is that you can see them, you can feel them, and so forth. The other classification of assets are intangible assets. And our whole discussion is going to be focusing on the intangible assets. And when we talk about intangible assets, we're talking about basically trademarks, which I'm sure you're familiar with, copyrights, patents, goodwill, when a company acquires another company as well. So these are the intangible assets. You cannot see them. They're human development. They're developed by the R&D team. So that's what the intangible assets are classified as. Okay. Next slide. We're going to talk about, I would like this slide to be a little bit interactive with everybody here in terms of the tangible versus intangible. If anybody can you know, put their speaker on or their mic on actually and tell me what's more valuable, the tangible asset or intangible asset? I would like, you know, to have it a more interactive session instead of us taking the lead. Anyone?
So we are discussing with each other. It's not necessary that you give us the right answer. It's only that we are discussing what you think, what's your thought. So please share with us, what do you think? Which one is more valuable? The tangible, the thing that you can see, it's physical, or the intangible, the thing that you cannot see, you cannot feel, it's intangible.
The tangible assets.
Intangible.
I would like to know, like, to answer and give a little, shed some light on why, which is more. So basically, you're correct. We right now have moved from the industrial age, basically, to let's say the a knowledge-based economy. So right now, we are all living in a knowledge-based economy, and based on that, that means a lot of intellectual property is being created as we speak. So we put the picture here of basically the iceberg. So, you know, you always see the tip of the iceberg. And that's basically how we can classify a lot of companies, basically, on terms of the tangible versus intangible. You see the building, you see the properties that they have, the investments that they have, but you don't see what's driving this company, whether it's from the R&D team, whether it's from the brand equity. So this is intangible. You cannot see it physically. And right now, because we are in a knowledge-based economy, you can actually see, I'll give you an example right now. If we go back to the 70s, and I don't want to be too technical in terms of finance, but if you're familiar with the S&P Standard & Poor's 500, where the major companies in the listed stock exchange of the US stock market, back then in the 70s, around 85% of the assets, of the company's assets value were actually tangible assets, land, building, real estate, and so forth. Now, if you look at the top companies in the stock exchange of Standard & Poor's and NASDAQ, you will notice that roughly 97 to 98% of the company's assets are actually intangible assets: brand equity, trade secrets, the copyrights, the trademarks. And that's what's being, and these are companies that we are all familiar with when it comes to looking at basically, and we use them, such as Microsoft, Google, and so forth. So this is two short slides basically depicting how the intangible assets are moving in terms of value from the 70s to the present day. And if you look at all these companies that you can see on the chart on to the right of you, basically, you'll see many companies that you're familiar with. Apple right now is $2 trillion. If you look at Apple, I mean, from the latest financial statements, they have the headquarters that cost them $5 billion. But we're looking in billions and billions of dollars, which are derived from IP, trade secrets, the software, and so forth. And that's what's deriving the value of the company, because that intangible asset is the main source of revenue for those companies. I'll take a little bit local here. I mean, since all these companies are a little international, but let's go with Dubai. Emirates Airlines, they've reported that basically their brand, their brand equity, how much is it valued? Anybody can guess what Emirates Airlines brand equity is valued at? The logo, the brand, when you say Emirates Airlines. Can anybody guess? Anyone?
Billions?
Well,
Billions of dollars?
just feel free. Nobody's going to be judging you of right or wrong. I just want to participate with everybody, so you know it's more interactive, basically.
Billion?
So, come again?
It may be in billions, maybe?
Yes, correct. It's around $6 to $7 billion. So basically, and Etisalat is around 11 billion. So the brand, when you say Emirates, what does it mean? I mean, it's a trademark, right or not? When we mention the trademark of a company, basically it's what the perception. It's the perception of the brand, if I'm not mistaken. When you say Emirates, great service, great live entertainment, great destinations, facilitating between countries. And it tackles each consumer's needs, basically, when you think about a trademark or a company's logo, what it derives. And this is what we're looking at right now, okay? And that's the essence of all the global mega brands, basically, is what their logo pertains to the end-use customer, because that's what creates the loyalty, okay? So the next slide is basically, we're going to talk about the introduction to intellectual property rights. IP, intellectual property, is the creation of human mind, and it's a fruit of human creativity. Yes, but if you look at the history of all these things, basically it was a team of 10 or 5 working under a small room that created such a brand. Facebook, we all know the story, how it was created. Apple, we've all seen the movie. And when you go back in history, you see it was run by 2, 3 individuals that came up with an idea and capitalized on it and made it into what it is today. So everything starts in terms of IP at a small stage from an idea, and that idea becomes materialized by putting your blood, sweat, and tears into it and making it a vision, your vision into a reality, and that's owned by those individuals. So that's what IP is. It's created from humans. There you have land, property, and so forth. It's something else. So unfortunately, you know, what we see is a lot of inventors, you know, creators spend a lot of money and efforts to reach to the new creations. Correct. And what we see in the market, unfortunately, a lot of inventors, and this is what we're going to talk about later on in the presentation, is a lot of inventors right now, they focus on the technical side, but they don't know how to bridge the gap with the business side. And if you see in the history that most of the inventors are really not that wealthy when it comes to creating the patent or who were the minds behind it. Yes, they are the authors of that patent, but you know, sometimes you need a business sense to put into it to derive the economic benefits of this. And that's why you have companies such as ours and other consulting companies that ensure that bridge is basically fulfilled between the business and economic benefit side and the creativity side. So IP is a system that's protected these investors and creators to compensate them. It's very important that this is also going to be compensated for whoever comes on board. And we always see basically, you know, the exclusive rights. Like if I look at Avengers, who was the creator of Avengers? I want to be more practical, or let's say more relatable in terms of what we live and how we entertain ourselves. When we see the movie Avengers, such as, you know, Iron Man and so forth, and all these major characters, we all know that the creator of this is Stan Lee, who was the author of these comic books. But then again, when you look at the rights of it, and whoever purchased it is Disney. And Disney paid over $6 to $7 billion as well just to obtain the rights. So whenever Disney makes a movie from the Avengers, the full economic benefits of such a movie will go to Disney, not Stan Lee. Correct? So it's the same thing that applies to as well any person or inventor who creates something new. You have the author that is written by or created by the inventor. Then when we apply the patents, which we'll discuss later on, it's very important to say who has the economic benefits of this once it goes to mass production or it goes into the retail side of things. Please feel free. Of course, I know there's going to be questions and answers later on. So whenever we have something, just write it down so we can touch upon it after this presentation. Okay? So just to shed light on this, so when we talk about intellectual property, what is IP? You'll see it a lot. Patents, which of course we're going to discuss in today, and this is the major focus for the Dubai Pharmacy College, because that's the area that we're going to be focusing on. Copyrights, trademarks, designs, industrial designs and so forth, and trade secrets. So the types of intellectual properties that are going to be held at the university, we see these being derived, or let's say born, at the colleges and at the universities. The idea, the spark of the idea, happens where you are right now. From our experience with regional universities and colleges and how those students graduate and move on to the professional field, the idea is really established at the university stage when they're learning, when they're understanding. And it's very important that we make you understand at this point of time how to protect your IP before going into the market and people take advantage of it. So in the universities, if you can go back, Messina, sorry, there's a lot of things that can be patented, which is the R&D and the outcome of the R&D, the research that you as a team and professors do as well, the publications that you have in terms of insights, also that can be copyrighted. The software, if you develop a software within the healthcare system, that also can be protected. Logos for a brand or so, that also can be protected. So we're going to start by talking about the trademark. Trademarks basically is what you and I relate to when we see a brand. So when we see a trademark such as Cola, Puma, immediately you as an individual have a thought process in terms of what it is. It's the perception of that trademark. When you see Cola, what do you think of Cola? Soft beverage. When you look at the pharmaceutical companies such as Johnson & Johnson, Pfizer, GSK, and right now, with the COVID situation, the people who did not know what Pfizer was, who are not aware of the pharma industry brands, now are familiar with a brand such as Pfizer. You people know who come from different backgrounds that are not related to basically the pharmacy or healthcare, then, oh, there's a Pfizer. They have come to know what the brand is. And that's the power of the brand, is that they use that platform like we are here. They've created something new. They've caused a disruption in the market. And that's how trademarks are born as well. Okay. So coffee. I want to stop here by coffee. Does anybody know who Howard Schultz is? Anyone? Who is Howard Schultz? I don't want you Googling, by the way. Anyone who knows Howard Schultz? Anybody heard of Howard Schultz?
Is he the one who owned Starbucks?
Well, yes. Well, basically, he doesn't own it, but he was the creator, correct. So Howard Schultz, did not invent coffee, correct? The coffee was there. But however, he created a brand that basically people relate to. And with that, he capitalized on it. So if you want to grab a cup of coffee, basically it's 1.2 euros. But if you're going to grab a Starbucks, we all know that you're going to pay a premium to it. Why? Because it's a brand. And that brand, people associate with quality, prestige, if you want to call it, taste. It gives an indication of who you are as an individual. Correct or no? And that's what Starbucks capitalized on. So from an invention point of view, you don't have to basically reinvent something. They even bring something new, Howard Shaw. So I like to call them, they're entrepreneurial environmentalists. Basically, they've taken something that already existed and made it better. And that's a true entrepreneur, who's taken the product of coffee and took it to another level, targeting the masses and making, of course, billions of dollars. Okay? So that's the power of a trademark. And it goes across all the consumers and all the products that you see when you go to the shopping mall. Immediately you associate quality. When you want to buy a TV, you say, oh, Samsung, something. You know what you're getting because of that trademark. You know you're going for a healthcare company. When you go to get a medicine, of course, you see it's GlaxoSmith or Pfizer or Sanofi. You immediately, from a pharmaceutical point of view, you identify, or basically you filter that this is a quality product. Okay? So that's the power of a trademark. If you have anything. Okay. So we can go to the next slide. Industrial designs as well. This is Dina's expertise as well, so she can chip in on this.
Okay. So again, as Mr. Firas said, intellectual property is about intangible assets. It's about the things that we cannot see. We can see, of course, the trademark and the design, but we cannot touch this. It's intangible assets. So one of the intangible assets is the industrial design. And as you can see that it is about the design of something. So industrial design usually protects the appearance of articles. It may be 3D or 2D. Can you see this one? Of course, I'm sure you know. It's Corox. Corox is protected by industrial design. What does it mean? It means that no one can design the same, cannot use the same design and manufacture it. Why? Because the one created Corox has intellectual property right. It means that he can prevent anyone else to use the same design without taking his permission. And of course, anyone can use or want to use the design of this Corox, he has to pay money to the creators. So it is the idea about IP. It's not only to protect, it's also to gain money from protection of your rights or from creation of what you did. Can you see this chair? How much you will pay for this? A lot of money. Why? Because it's different. People are looking for, especially girls, and who are all girls, so they are looking for the appearance of something. Oh, this chair, I like this chair, I like this design, blah, blah, blah. But it's not only about the things that we can buy, it's not only about the chair, the coffee machine, the shoes, fashion, whatever, but also it is about the package. So the package of the medicines or the pharmaceutical compositions can also be protected by industrial design. Can you recognize this one? I think it is a design of Panadol, and this one is another brand for something related to respiratory system, I think. Both of them are protected in Europe. So it's not only that the creators or the designers of beautiful articles are protected themselves by industrial design, but also the pharmaceutical companies are seeking for design. Why? So why they want to protect this shape, for example, for Panadol? Why do you think? Maybe because it's beautiful. Do you think it's beautiful? The design of this or the other package of the medicine?
No, they want to have their own brand.
Sorry, again?
They want to have their own brand.
Their own brand, yes. But where is the brand in Panadol? There is no word called Panadol here. But I like your answer, because this answer will like drive us to explain the difference. Trademark is the name Panadol. So when you see Panadol, you know what you are, so you know this is medicine for headache or whatever. Okay, but this is the design of the package itself. And you're right. So pharmaceutical companies protect this package so people can recognize this. And it will prevent, again, as we said, and as Mr. Fras said, that intellectual property gives exclusive rights. Exclusive rights mean no one else except you can use this. So for Panadol, I think it's a pharmaceutical company who protected this design. It wants that no pharmaceutical company, no other pharmaceutical company use the same design. And it will be related to the customers. So when we saw this, without getting that it is Panadol or whatever, we recognize that it is the package.
Yes, it's basically what you're actually saying. It's the product appearance, and the product appearance, color, design, so forth, creates an association with the brand from a consumer point of view. So manufacturers really capitalize on the product appearance because it gives that mental linkage with the consumer. Okay, so when you say, let's say, a color of a product, the bottle itself, the packaging, the shape of it, you know, we all know a cola bottle. The sound as well comes into this as well. You know, if I say ta-ra-ta-ta-ta, you immediately know I'm talking about McDonald's, correct or no? Smell, scent, and so forth. All these are IPs that create that linkage with the end consumer, whether it's the artwork, the color, the packaging. It's how you communicate with the end user, okay? And I might also want to add something that is very important here in terms of trademark, if you don't mind me stepping a little bit back, Ms. Dina, on regards to, you know, your trademark, you can lose it. How do you lose it? When it becomes indistinctive. And what do I mean by that? So if you go back in time, speaking of pharmacy, aspirin. Aspirin was a trademark on its own. However, everybody started using, you know, aspirin. It became too generic. It lost its heavyweight in trademark. You know, it became used as take an aspirin. You have a headache, take an aspirin. People associated it with a medicine to recover instead of the brand, although aspirin was a brand, as a painkiller, actually. Xerox, you know, the machine that does photocopy, it lost its trademark because I give you a paper, kindly Xerox this. You started using it as a verb. Right now, Google, of all companies, which we know is one of the biggest companies out there, in the information memorandum for all investments, you know what their biggest risk right now is, what they tell their investors? If Google becomes a generic word. When we say, oh, can you find out this? Please Google it. The verb Googling it, Google itself hates that verb because they don't want it to be as a search engine, like as a verb. Then it loses its trademark. And what does Google do right now? When it hears people in the media say, Google it, they say, hey, kindly revoke it, and they charge them for it because they are diminishing the brand itself. And it's becoming too very general, which we also do. Google it, see what finds out, and we take it. But that's the biggest risk for Google conglomerate, is when we start using Google as a way of, you know, searching things rather than the brand itself. So that's how you can lose a trademark. So it's a sword that cuts both ways. It's very vital how, you know, the market perception is on that. Okay, sorry about that.
So now we are going to talk about the copyright. Okay, so intellectual property, now we know about trademark, industrial design. There is also copyright. Copyright is a literary and artistic work. So, for example, books, when you write a book, when you write an article, when you publish anything on the internet, it's protected by copyright because it's your own work. It's your own creation. Music is copyrighted. Artwork, drawing, even software, dramatic works like films, movies. And
even the Apple sound, when we know what the Apple sound is, that's copyrighted.
And also, let's talk about this, Instagram. You want to talk about this?
You know, we have many, everybody's right now social media savvy. So they have the Instagrams and their followers and they take lovely pictures. And unfortunately, you see somebody who take pictures, whether they're traveling the world, and they put copyrights under their picture, but it's not copyrighted. You know, this is so that this is ours, so nobody else can use it. Putting the word copyright does not exempt other users from taking that picture and actually using it. So let's be more relatable. If you want to open basically a coffee shop, let's say, and you want to open a restaurant in one of Dubai malls or Amar's properties, and you want to say that, oh, I have a store basically next to this mall because it's a high populated area, it's a very touristic destination, you should all get approval from Amar to use their background and skyline and building, because they are monuments in Dubai, as we know. You know, they are landmarks of the UAE as well. You have to take their permission if you want to promote your brand with them as a background. That's what copyright is, especially in that. Instagram, your pictures, you write a book, you right now as pharmacy students, I'm sure you're doing research and publications. People eventually are going to take that and use it. How are you protecting yourself as an author in terms of, you know, what you come up from research, articles, and so forth? And of course, as a college as a whole, because this is eventually data. And this data can be used for any business that can come in from a private sector and use that and make a business out of it. Because the research is done and people pay millions actually to get this research, right? We have many companies that we deal with who are semi-governmental that they have 30 to 40 million data. And private sector companies come in and they use that data and create algorithms and so forth. And the person who has that data takes a back seat in the business without taking $1 on the benefits of it. So it's very vital. Any institution that has data that can be materialized should ensure its protection. Okay?
Okay, so now we are going to talk about patent. Okay, I think that patent is the most related field to you as a college, because you are doing a lot of research, you have a lot of R&D, so patent is very, very important to you. That's why I need that you will be like interact with me. I don't take this session to be only one way. Okay.
How many participants do we have right now? I think 88. Yeah, at least 88.
We have in live stream as well.
Okay.
Okay. So please interact with me in this session because it is the most important to you, the most related to your field.
Yes.
So I want to make sure that you understand every word in this session. I want you to protect yourself by patent system. It's very important for you as a student, as a professors, and as a college. So, what is a patent? Did you hear about this term before? I'm sure you hear, but what is patent? What do you think?
Patent is to protect my idea from its. It's to present my idea to the organization, and then they can protect it from anyone copying it.
Which organization you will represent your idea?
Not sure about that, actually.
Okay. So, any other answer?
A novel idea, maybe. So it's a novel idea. We are making a research. Then I came to a new idea, which is not made before. So I'm trying to make it as a patent. So anyone want to use it later, they have to take something like permission, or we have to contact, for example, if I'm talking about pharmacy. So if we want to make a new drug, for example, we want to protect the drug or idea of how to make this drug. So we preserve it or make it as a patent, and then we can later maybe contact any industrial companies, so we can make something like collaboration or give them our patent, something like that. Thank you.
Okay, thank you. So
Well done.
okay, so yes, patent is exclusive right granted for an invention. So again, all intellectual property are exclusive. No one except you can use this invention. No one can use it without your permission. They have to pay money for you to have license and use your invention. So patent give exclusive right for the inventors who invent something. Okay, this exclusive right is not forever. Nothing lasts forever. This exclusive right must be for a certain period of time. So for patent, it will give you exclusive right for 20 years. So if you invent something now and you will apply for a patent, you will protect it for 20 years. No one can use this invention without your permission for 20 years, which is very long period of time. And if someone do this, he will be under the, like, you can sue him and take a lot of money. Okay. So what is this invention? Is there a certain definition for invention? Is there something that you can call an invention and something that no, it's not invention, it's only discovery, for example, or whatever? Do you have
something
yes?
new? It should be something new and not has been done before.
Sure. Thank you. What else?
The idea should be completely novel. It should not be based on other research or another idea.
Yes. Any other answers?
Something that didn't exist before. It was made from scratch.
Okay. Amazing.
It should be different from the others' inventions.
Different. Okay. Thanks all. So
Great answer.
yes, great answers. Okay, so as you said, invention should be new. We'll talk about this later. But now what I want to say is that invention, there is no definition for invention. Invention can be anything you can think about, from the smallest article or tool to the largest thing you can think about. Okay, it can be for product or the process also. So if you have a new technical solution to a problem, if you invent a product, new product that solve a problem that is exists, it's an invention. Whatever this product is, but it's at the end of the day, it is an invention. So again, it can be process. So if you have a new way of doing something, it's a process of doing something, but this process solve a problem in the art. It's also an invention. So there is no definition for invention. Anything can be invention. It's a product, it's a process, it's a small tool, it's large machine, whatever, it can be called invention, and it can be protected by patents. But under one condition, as you see, necessity is the mother of the invention. What does it mean? It means that there should be a problem. There should be a need for your invention. You solve this problem, and so you want to say something? Okay, you solve a problem in the art, you solve an existing problem, and you come with new idea, new product, new process to produce something. So it's an invention. And here, as you can see, robot is invention. Mobile phone. Actually, mobile phone is not an invention. mobile phones are many inventions. Maybe it will reach to 500 inventions only in this mobile. Why? You have camera, you have technology, it's a lot of technology in the mobile phones. So maybe one invention contains or has a lot of patents inside it. Also, the train, if you solve a problem in what's existing, you can protect it by patent system. Any machine, as you can see, is a patent, is an invention, and can be protected by invention, by patent system, but if there's a need for your invention. If you solve a problem, okay? So I want to ask you a question before moving to the next slide. What do you think if I have, okay, let us say that there is no mobile phone. We don't know something that is called mobile phone. Okay, we have the ordinary phone. And I came with an idea. Okay, I have an idea of mobile phone. So you can use it anywhere when you are in any place, and you can use it, and it will have a camera. You can take pictures of this mobile phone, whatever. So do you think that my idea can be protected by patent system?
Why not?
Yes, yes.
It is still an idea.
But it's not.
So do you think that I can protect my idea? Or I should produce this mobile phone first and then seek for patent protection?
Be interactive, guys. Where are you?
Anyone can take and work on it.
Anyone, sorry?
They can take and work on it.
Anyone can take.
Salma, please. Yes, again, Salma.
Yes, doctor. I was saying that I'm not sure, but maybe it cannot be fully protected, and then anyone can take, or maybe they will buy the idea and work on it, since it's just idea.
Thank you, Salma.
We have also Shan. She want to comment?
Yes, doctor, I was saying the same thing. Even this idea should be protected, because like anyone can work, like use the same idea and can, before production itself, you have any idea, it should be, and like, we should tell this to someone, and then.
Yeah, because it's gonna take a lot of time until the product is finalized. So by the time someone else could have stolen the idea.
Thank you a lot. So it's not only for patent system, it's for all intellectual property rights. So if you have an idea for a story or a movie, you cannot protect an idea. It should be something that, like, for example, you know about Romeo and Juliet. Yes, you know the story, of course. You know about Chris and Layla, whatever. They are all the same love story. They both love each other, but then they killed one of them killed himself, blah, blah, blah. So they all have the same idea. But what happened? Why they are all protected? Because each one writes this idea by his own words. So it's his creation. He did this by his own words. He make an effort to write this, and they are all different. When you read them, they are all different. They have the like the personality of the creators. The same idea in the patent system. You cannot protect an idea. I have an idea of a mobile phone. So what? How I know that this idea will be true? So intellectual property in general don't protect an idea. It protects something, the expression of the idea. Okay.
So the idea has to go on paper, basically.
On paper.
You have to write it. You can't keep your idea with your head and say it was my idea. If you do not document it and say, write it down, give a brief background about it, then it's always going to be for you, and it's not going to be able to be protected. So whatever ideas you have, write it down, summary, even how small it is, it's worth writing, and then put it back into the copyright as well and the patent.
So now it's like general idea about patent system. what is the invention, what type of inventions can be protected generally. But now let's be specific on the pharmaceutical field. So what types of invention can be patented in pharmaceutical field? So you are pharmacy company, pharmacy college. So what type of invention, what type of, what do you think? What can be protected by patent? New field.
Drug molecules.
New molecule. Amazing. What else?
Modification of a certain dosage form.
Thank you. Modification of something already exists.
New formulas.
New formulas. Amazing.
Sometimes new processes of manufacturing.
Amazing. So thank you all. So patent. Okay, this a general like look at this. Patent can be granted in all fields of technology without exception. Okay, so it is like general in patent system. In USA, there is a court decision said that anything under the sun can be protected, which is human made. So anything what you can think about, as long as it's human made, it can be protected under the patent system. Whatever it's pharmaceutical, it's blah blah blah, it can be protected. So for pharmaceutical, as you said, thank you, method of producing pharmaceutical compounds, composition, formulation, blah, 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 can be protected by patent system. But again, can you remember the last slide? Necessity is the mother of invention. So you can protect a method of producing pharmaceutical compounds or composition if there is necessary for this invention. In other words, if it solves a problem in the field. I'll give you an example. If we have like a pharmaceutical composition, in order to produce it, you have to use liquid nitrogen, which is very difficult to deal with. It's very complicated, it's very costly, but someone else invent a method of producing this compound, but with less risk, let's say, yes. He solved a problem. It's not any more complicated. You don't have to use liquid nitrogen, blah, blah, blah. It's more easy, but it's new. So it can be protected by, or you can see that if you have pharmaceutical, the next example I'll say now after this. So you can protect also new pharmaceutical composition or new chemical compounds that can be used in treatment. New pharmaceutical compositions, like you said that invention is something new. No one before you did this, it's from scratch. Actually, invention shouldn't be from scratch. It can be only modification for something that it is already exists. Like what? Like here, the pharmaceutical composition. You can add some compounds together in the same pharmaceutical composition, but this new composition solve a problem. So for example, if you have a material or a compound which is not stable, for example, the erythropoietin, which is used to treatment of some anemia or whatever, as I know. So, and correct me if I'm wrong. So this erythropoietin is not stable at room temperature. If I invent new composition, this erythropoietin to be stable in room temperature, it can be sold in pharmacies without the pharmacy don't have to put it in fridge or whatever. So it's new invention. Also, erythropoietin is known, but I put it with other compounds, so it's now more stable. I solve a problem in the period art. So, or in the field, I solve a problem in the field. So it can be protected now by patent. Okay. Any problem? There is something that you cannot understand? You need more clarification before going to the next slide?
No, thank you so much.
So Again, patent can be granted in all fields of technology without exception. It can be protected in pharmaceutical, biotechnology, engineering, medical tools, whatever, but with some conditions. We have 3 conditions to protect the patent. The first condition that you all said is the novelty. This invention should be novel. So no one else in the field should reach to this invention before me. I reach this invention first, and then I file for a patent, so I get protection. Okay, so I should be the first one who invent this invention or who reach to this invention. Second condition is inventive step or non-obviousness. What is called about inventive step? How the invention is non-obvious? What do you think? So it's not enough that I reach to this invention before anybody else. It's not enough that my invention is new. It should be also invented or not obvious. So what is the meaning? What do you think about not obvious? What type of inventions that can be not obvious? And not obvious for whom? Again, feel free.
To the audience or the customers?
It's not obvious to the customers. Okay. Any other suggestions? Please share with us, what do you think?
And obvious for the competitors?
Not obvious for competitors.
Yes.
Amazing.
Guys, you can write on chat, we will read, no problem.
Okay. What you said is correct, but let us think about something. If, for example, we said that, again, the example of erythropoietin, okay? If I have this erythropoietin, I invent erythropoietin, and I add another compound, which is compound A, but this combination will make the erythropoietin more stable in room temperature as said. No one before me reached to this composition, which is erythropoietin with compound A. So no one reached to this, so it is novel. But does it mean it can be patented? No. For normal people, for customers, for blah, 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 they think what I did is amazing. It's new. It's a huge thing. Because what? Because this compound is not stable at room temperature. I put another compound, so it is stable for longer time and at room temperature. But your pharmaceutical college, from your study, you know that this compound, which is compound A, is normally used with any other compounds to make it more stable. So you know from your study that when I add compound A to any pharmaceutical composition, it will make it more stable at room temperature. So did I make something huge? Did I invent something? What do you think? Like, don't be shy, just share with us what you think. There is no right answer and wrong answer. If I combine 2 compounds, which is known in art, that or known for the experts like you, or for the one who study pharmaceutical science, that the compound A is used with any other compounds to make it more stable, to make it can be stored in room temperature. for longer time. So did I invent something doing this? Is it obvious or non-obvious for the one who studied science?
Obvious.
It should be with a new name. It should be with a new name, new design. So for the popular, it will be as a creating things. If it will be at the same name, it will be, it's not as something new, a new event.
Okay. Any other idea?
Yes, it will be not something a new invention.
It will be Surima.
It will not be a new invention.
Will not be, but I'm the first one who reached this invention, so it is new. But maybe you mean that it's not obvious, or it's obvious for anyone in the field, yes?
Yes.
Okay, so there is a big difference between something new or novel and something which is not obvious. Something new means that I'm the first one who reached this idea. Not obvious or it contains inventive step means that I did something different, something creative, something which is not obvious for the people who have knowledge in the field. So for you as students in pharmaceutical science, you know that it's obvious. I have this problem, and the first thing I will think about is to add compound A. Why? Because it will make this unstable compound, it will make it more stable. So for you as students, as the one who understand, as experts in the field, know that it's very obvious. Maybe for other one, for an engineer, wow, he makes this thing stable and it's not stable before, they will think that it's a major difference. But in fact, it's not a major. It's only minor difference. It's obvious for the one skilled in the art or for the one who have ordinary knowledge in the art. So the inventive step, when you can think about it's inventive or not, you have to think about the people who already have the basic knowledge in this field, in this particular field. Okay. So the last condition is industrial applicability or industrial applicable. As we said, if I have an idea of the phone, it cannot be protected because why? Because it is still an idea. There is no expression of this idea. It's still an idea. Like the idea of having a new vaccine for COVID-19. It's still an idea, but what is this vaccine about? What is the compounds I used to make this vaccine? How I did it? Okay, so the idea itself is not protected, but it should be accepted. So I don't have to wait until I finish or I'll produce this idea. So I don't, if I have an idea of the phone and I know how to manufacture this phone, what I have to add or to make in order to reach to this phone, I don't have to wait until I produce this phone. I can file a patent application. If I have an idea of COVID-19 vaccine, I cannot patent this. But if I know what is the compounds I will add or I will put in this vaccine, I can then patent it. Even if I didn't manufacture this vaccine yet. So if I make vaccine and I did some genetic modification for COVID-19, but I know which gene I will make mutation in it or which gene I will modify it in order to reach to this vaccine, it's an idea that can be protected. Why? Because if someone other than me, if someone expert in the field, and he reads this step, he knows that I put this compound A in concentration, blah, 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 compound B in concentration, blah, blah, blah. If he applies this step, he will reach to this COVID-19 vaccine. Okay, so you don't have to wait until you have a prototype or until you have a product in your hand. Once you have an idea, you know how to reach to this idea, you know that it will work, then you can file directly a patent application. Why? Don't wait for others to reach to the same idea you have. Don't wait to, okay, now I have an idea, I will communicate with pharmaceutical company to produce this idea, and then I will seek for a patent. No, do the opposite. So try first to seek for a patent application if you know that your idea or what you did will work. Okay. So again, we have 3 conditions to have a patent protection. Novelty, it should be new. No one before you reach to this invention. It should be not obvious for the people who are working, or the people who are expert in the field. And it should be applicable when it will go to industry. Okay, so there are 3 conditions. Anything under sun can be protected by patent application, but or patent system when they have 3 conditions: novelty, inventive step or non-obviousness, and industrial applicable. So who will determine these conditions? The patent office. In each country, there is a patent office who examine these patents and apply the 3 criteria. So I was a patent examiner at the Egyptian Patent Office before coming to Dubai here and join Al-Mazmi Advocate. So during my work in patent office, I was working in biotechnology field. So before, when I was working in patent office, I have an application in biotechnology because it's my field, and I search for what is exists before this patent. So I have this patent which is filed today. I will search what was filed even yesterday, what was published in the field, what was published anywhere in the world. And when I have this search, when I do my search, I have some documents, some publications, and then I will examine the 3 conditions. Is it novel? Yes, it's novel because no one before this inventor reached to this invention. Is it obvious for me as the one who is working in the field? Yes, it's obvious because it's easy for me, or I can reach to this invention easily. Is it applicable? If I do 1, 2, 3 as the inventor as the inventor guide in the application, if I do these steps, will I reach to this invention or not? If yes, then yes, it's applicable. Okay, so patent office in each country will examine the patent application and determine the 3 criteria: novelty, inventive step, and applicability. So we talk about the inventions that can be protected or patented in pharmaceutical field. Now we are talking about, or we will talk about something else, which is the invention that cannot be patented in the pharmaceutical field. So now we are going to talk about the opposite. We talk about what can be protected. Anything under the sun can be protected. Anything it has the 3 conditions: novelty, inventive, and applicable can be protected, but there is some exceptions or exclusions from patentability. There is some invention that if you have, it cannot be protected by patent. Okay. These exceptions or exclusions are different from one country to another. But we are talking here, I'm talking about the law of the UAE. So we are talking about our local law. What is not protected by patent system: plant variety and animal species. So if you have, I don't know if you hear about Harvard rat or not. Anyway, it's rat that they, rat, they modify the genes or the genome of this rat. So I think it has a type of cancer, and they are using this to test the new compounds that can be used to treat cancer. In some countries, this gas is protected. But in most countries around the world, it's not protected because most countries don't protect plant or animal. So if you have a new plant, if you invent a new plant that is resistant to insects, for example, it will not be protected by patent system. There is another protection under intellectual property also, which is called plant variety, but it's not protected with plants. But the method of producing this plant may be protected. Okay, so if you make a modification in the genetics of this plant, the method of doing this modification to introduce a new plant which is resistant to insects, it can be protected by patent system. So the plant itself is not protected, the animal itself is not protected, but sometimes the process of the method of producing this plant of animal can be protected. It depends. If it's genetically modified, it can be protected. If something else, maybe it's not protected. Also, diagnostic method is not protected. Method of treatment is not protected. Surgical operations are not protected. And also the inventions that may lead to violation of public order or morals are not protected. So do you have any questions here? Any questions? So may I ask you one question? Okay, let us say that I have, my invention is COVID-19. I'm talking a lot about COVID-19 vaccine because it is what is outside. So I want to join what we are speaking about with what is going outside. So if I invent new COVID-19 vaccine, do you think it can be patented or not?
Only if you know the components or how it will be produced.
Okay, my vaccine will be, I use the COVID-19, but I know the gene which is responsible for this disease and I will remove it. So I make a new, let us say it's attenuated vaccine. And I use this attenuated virus, attenuated COVID-19 virus, and I use this attenuated virus as a vaccine for patients. And my invention is this COVID-19 vaccine. So do you think it's protected or can be protected by patent or not?
I think they don't invent any new idea in this case. I think here there is no new idea. It is just attenuated. We are using attenuated virus, which is always used. There is nothing new. This is the normal way of producing vaccines. But maybe if like they make a new idea in the creation of the vaccine, they are adding something extra. They are formulating it in a new way, which is not there before. I think in this case, it will be a patency.
Any other answers or?
I guess having a vaccine as itself for this new virus, I guess it's considered as a patent.
So do you think? So do you think that having a vaccine for this virus is patented because it's new? There is a need.
Yes, me too. Also, as already COVID virus, it's a new. So to create a vaccine, it's a patent.
Yes, amazing. So any other answer? Any other thoughts? All of you agree with this? So yes, you are. So yes, you are right, all of you. Thank you for your answers. And I like how you think. Okay, COVID-19 vaccine can be protected, but let us think. It's new virus, so anything I will do for this new virus will be new because no one before me reached to this. Simply because it's like it's new virus, it's new species even of virus. So anything I will do, any modification I will do for this virus will be new. And I like your answer. No one before me reached to this vaccine, and there is a need, there is a bad need for this vaccine. So it can be protected by that. So thank you. But I will give you another example. My invention is a method of treatment of COVID-19 patient using COVID-19 vaccine. Can I protect this invention? It's
No.
method of treatment
No, it's
of
not
the
an
COVID-19.
invention.
Sorry?
It's not an invention
Not an invention. Why?
because a method of treatment might be using other reference of other methods of treatment. So it's nothing new. We're not using any new novel idea. We're just implementing previous knowledge about other diseases similar to COVID-19 and implementing it.
Amazing, thank you. I will not give detailed answer.
Thank you so much.
So yes, so it is the rationale of my question. The vaccine itself, or the compound, the pharmaceutical compound itself can be protected by patent if it has the three conditions. The method of producing this vaccine can be patented if it has the three conditions. So it is new method of producing or whatever. But the method of treatment cannot be protected. Why? Because it is one of the exceptions from the law. So even if I invent or I reach it to a new treatment method, it cannot be protected. If I reach it to a new surgical operation to treat something, to treat a disease in a patient, this surgical operation is new, it's not obvious, it can be applicable, everything, all conditions are there, but it can be not patented. Why? Because it is excluded, or it's one of the exceptions from the protection by the law. So we have a lot, as we hear, we have a lot of regime to protect, or it's those regime or treatment regime to treat COVID-19 patients using Panadols and using vitamin C, blah, 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 whatever the regime is not protected. So any question in this slide before moving to the next one? Okay. So I think now we understand the idea behind the patent system. So we know what is invention, what can be patented, what cannot be patented, what is the conditions of protecting, of getting a patent or grant a patent for pharmaceutical field or even for the other fields. So these conditions are applied for all fields, whether it's machine, it's new composition, it's blah, blah, blah. So now we know the whole idea behind the patent system. The next slide. Practical. So now we are going to talk about what is the best. Oh, okay. So before we are going to the best method to apply for a patent application, we are going to talk about the effect of patenting pharmaceutical composition. Okay. Okay, I will explain this. It's 2 slides. I will explain, and then we'll have break before going to the practical issue, which is what is the best way you can do before to file a patent application and get it granted by the patent office. So it's very important. I will first explain this again. The effect of patenting pharmaceutical compositions. So pharmaceutical compositions is a specific field. It's not like patenting a machine. It's not like patenting a computer. It's not like patenting anything else. Why? Because it is related to human life. It's related to health. It's related to one of human rights even, which is access to medicine. So patent system is not only about protection. So it's not only about that the pharmaceutical company make a new invention, I will patent. Another pharmaceutical company, another invention, patent, 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 patent. It will have a bad effect on the access to medicine. Why? Because as we said, that patent system and all IP rights will give exclusive right to its owner. So a pharmaceutical company invent new vaccine, new medicine for COVID-19 or new vaccine to COVID-19, can you imagine? I think you can imagine that this pharmaceutical company is the only company that will have the right to manufacture, to sell, to use this COVID-19 vaccine. So can you imagine what will be the effect of the access to medicine for anyone? So it's very important when it comes to pharmaceutical composition, you know, the effect or the consequences of protecting the pharmaceutical composition. It's not only about protection, we should make a balance between the access to medicine and the patent system, or the right, the exclusive right given to pharmaceutical companies or to anyone which will prevent any other companies or any other person from using this product, pharmaceutical product, this new process of producing a vaccine, of producing a pharmaceutical composition by others. It's very important to know the consequences or the effect of protecting pharmaceutical companies. Again, when we have a branded medicine is expensive for some people, for most of people, actually. So how much Panadol costs? And how much is a generic medicine which have the same ingredients of Panadol cost? Maybe here is the situation is different, but I will give you an example of Egypt. In Egypt, I bought Panadol for 60 Egyptian pounds. I bought the generic medicines which has the same ingredient of Panadol with only 5 pounds. So the difference is more than the double. Okay. It's always about the brand. This medicine is a brand medicine. It's produced by Pfizer, by Sanofi, by blah, blah, blah. And I trust this company. I pay for this medicine because it's well known. I heard about Panadol, so I expected that the effect is better, or because I trust this international pharmaceutical companies. I trust the brand of the medicine itself. So usually branded medicine are very expensive. And for some people, especially in like developing and less developed countries, is very expensive. While generic or the medicines which is produced by local companies is less price. Okay. The problem with the patent is that the local companies cannot produce this medicine if it has a patent. So it will not only that this pharmaceutical or international pharmaceutical company has exclusive right to produce and manufacture this medicine, but it's also like local companies cannot produce this medicine because it's patented. So can you imagine how much expensive will be this patent or this medicine that is patented? It will be very expensive. So it's very important to make a balance between the access to medicine and the patent system. And it is the rule of the patent office. But I just give you an idea of what is going on. Okay? I'm not saying that I'm against protection of patent. I'm not saying that I'm against giving patent to pharmaceutical companies. No, patent is very important. Pharmaceutical companies will not spend a lot of billions of money and effort on R&D system and time to come up with new molecule or new composition that will treat a disease unless they know that we gain money from this. And how they will gain money? Simply by having a patent for this medicine. So patent system is very, very important. It will encourage pharmaceutical companies and inventors in all fields of technology to come up with new inventions and new ideas. Why? Because they will have exclusive rights for 20 years. This 20 years, they are the only ones who can produce, who can manufacture, who can sell, import, export this medicine or this invention. So patent system and intellectual property system will compensate the inventors and the creators of the time, money, and effort they spend to come up with this new idea. We have to encourage inventors and the patent system because otherwise no one will spend like only $1 dirham to come up with new idea. So it's very important to protect companies by patent system, but it's also very important to take the human rights or access to medicine into consideration when it's come to the pharmaceutical composition. We have to think about, okay, I will give for patent offices because I was working in patent office, so I will give this pharmaceutical company patent, but I want to make sure that it is served. I want to make sure that it is novel, inventive, and applicable. If the three conditions are there, I will give them a patent. That's why we have examination or technical examination in almost most offices around the world. So it's about patenting. Patent is very important, it's critical, it's significant, but it's also protecting or make a strategy or a policy to protect people, and access to medicine is very important. It's like something like treatment against profit. It's something like history, what happened before. I just want to share it with you. So in 1998, some pharmaceutical companies sued South Africa for allowing the Minister of Health to make affordable medicines available to protect public health. In this time, the AIDS virus, or the AIDS disease, or HIV virus, was very, very famous or common in South Africa. Almost 20 of adults in South Africa have HIV in this time. And in some communities, the infection rate is almost 70%. 20,000 people died in each month in South Africa from AIDS. So the numbers are very, very scary. So that's why in this 1998, the South Africa allows the minister to make affordable medicine or cheap medicine, generic medicines for the medicines that is patent. That's why the pharmaceutical companies who have the patents for this medicine saw the trend. And the president of this of South Africa in this time was Nelson Mandela. I'm sure that you all know. He has a motivation with the help with some non-governmental organizations around the world. The world and the people who are supporting the access to medicine, the access to cheap medicine, especially during this difficult time in South Africa. They are all work together, and actually they change the world. So after this time, there is something. It was compulsory license. It was found actually before this time, but they make a huge change in how it's implemented, the implementation. So what is compulsory license? Compulsory license, simply, it allows countries to grant local companies the right to produce affordable medicine or cheap medicine, but under certain conditions. What is this certain condition? Health crisis or pandemic. Like for this time, during this time period, it was very, like it was problems that killed huge amount of people each month. So what Mandela with non-governmental organizations did, that they allow and they make this law into enforce. So after this time, the Minister of Health can make a decision to give local companies the right to produce the patented medicine with less price or low price, to allow people to buy this cheap medicine and get treated from disease. Why I'm saying this? Because I will not open the discussion for this issue, but I want only to open your mind. I want only to make you think about the current situation. COVID-19. Can we do the same because it's pandemic, because it's health crisis, or not? You will not find clear answer because it's still new, it's still under debate, huge debate actually. But just to give you an idea about what happened. Usually countries, policies, and are not care about only protecting the pharmaceutical company. They are caring more about the balance. They care about the public health, and they care about, they want to make balance. If this balance is not is affected, is not like distorted or whatever, it will have bad effect. So if the countries go to prevent the pharmaceutical companies from taking patent, it will affect on the public health as well. Why? Because pharmaceutical companies will not produce or will not come up with new medicines that will treat diseases which we need to have a medicine for. And at the same time, if they keep protecting pharmaceutical company, it will have bad effect on the local companies who cannot produce these medicines, and it will have bad effect for the pharmaceutical field on the public health and access to medicine. Okay, so now I finish, and the next slide after it will be the best practice to apply for patent application. Here I will explain to you. It's not only how to file a patent application because it's easy. Anyone can do this easily. But what is the practice you can do or you have to do to get your patent granted? Because patent offices will examine the patent, as we said, and it may grant a patent, it may accept it, and you will have protection for 20 years, or it may reject it and you will have no protection. Okay, so here I will explain to you how to save your money and effort and get your patent granted by the patent office. Okay, and it can be, what I'm going to say will be applied in any offices, not only in the UAE, in any office around the world. Okay, so Dr. Hana, how long will be the break? I'm not sure.
Actually, 5 minutes will be okay, or do you want more? Okay, so 5 minutes, guys, and inshallah we will proceed. Inshallah, start again. Thank you so much.
I guess it's 10:35 already. If you wish, Miss Dina, you can start. It's muted, yeah.
Okay, we can continue now. So the best practice to apply for a patent application. What you have to do before applying to patent application to get your patent. First, you have to search before start the R&D research. From my experience with like other universities and even research institutes, they are not doing search before starting their research. What they are doing is that they have an idea and they think, okay, this idea will work. It's new. I cannot find it anywhere. I cannot find it in the market. And they work, spend a lot of money, effort to come with this idea. And when they apply for a patent to the office, and from very, very simple search I did in the office, I give them document, sorry, your invention is not new. It was even published in early of 20 and so on. So it's very, very important to do a search before starting anything. Look at this. You don't have to reinvent the wheel. You have only to improve it. Don't spend your money on something that is already exists. Just try to improve what is already there. If there is already a vaccine for COVID-19, okay, no problem. You can still working to come with a new or to invent a new COVID-19 vaccine. But before doing this, you have to know what is in the field, what is already exists, to know how to improve it. I have a case in our group firm. It was an inventor, sorry. He make a new invention about EC. This EC have filter to remove bacteria, some bacteria and viruses and so on. And he thinks that is amazing. And during this time of pandemic and COVID-19, it will be patentable and it's amazing because he cannot find it in the market. And we are offering search service here in the law firm, and I did a search, and he was shocked that I found a lot of publications about his invention, and it's not new. Of course, I will not tell you what he did exactly, but I'm talking about the idea itself. The idea is not new, and what I found has the same, like the same products he used, and the same method as well. So it is very, very important to search before you start R&D. The good news is when I gave him this publication, he was very smart, he was very flexible, and he just improved what he did and what is already exists. But it's better to start it from the beginning. It's better to know what is already in the field, what is already exists, and then start to improve it, to come with something new, something that the society even needs, not something exists. So doing this research will save your money, your effort, and your time, and will increase the opportunity that you will have a patent for your invention. And it will also like make difference for society. You will also benefit the society because you come with something new, something that they need, not something that is already there somewhere. It's better if you have to ask help of an expert of search because they are using search strategy, and but I'll give you some database that you can use as well in the next slide. Just my advice is to search in patent and non-patent database as well. Because I know that some of researchers and professors are doing search using only non-patent database, which is very useful, which is amazing. Like in CPI, whatever you are using, it's very important to search for non-patent databases, but it's very, very important also to search for patent databases. Why? Patent databases has huge information that will benefit you. The most recent inventions will be published in patent before being published anywhere, in any journal, in any database around the world. So, of course, we all know television. One day in the past, television was an invention, was a new invention. This new invention was published in patent 3 years before it was published in a scientific journal. So when you are searching for patent database, you will have the most recent inventions. You will know what is going on, what is people are modifying, what is they are working on these days. Okay? So it's very important to search for patent and non-patent database. Don't only depend on non-patent databases. So where we can search for patents, there are a lot of many free databases, so some paid databases and some free. I will give you an example of free database, which is called PatentScope. PatentScope is organized by WIPO. What is WIPO? WIPO is a World Intellectual Property Organization. It's one of United Nations organization, but it is specialized in intellectual property. Most treaties and conventions around the world in the IP field or the intellectual property field are managed by WIPO. So WIPO offers this free database, which is called PatentScope. This free database contains about 93 million patent documents, and every day the number increases. And you can using this database, you can search on whatever fields you can search or you need. So you see this? It's screenshot from the database. You can search here for anything you can imagine. If you select or press on this arrow, you will have a huge list that allow you to search in many fields like abstract, title, description, even the applicant name. If you want to search about medicine by Pfizer, for example, or how many patents Pfizer get for insulin, for example. You can search by the name of one inventor. You can search even by date. So I want all patents in this field before 2019, for example, whatever. So you can search by numbers, by whatever. You can search also in many languages. You can search in Arabic, English, and there is another language. I'm not sure which other language because I'm not using, but you can search in English and Arabic anyway. And here you can also change the operator between and or. So I want this and this and this, or I want this or this or this. In case if you are using synonyms in search. So this database is very, very important. It's a huge amount of patent. Whatever your field, whatever what you want to search about, you will find here, and it is the most recent publication around the world. All inventors around the world, the knowledge or the awareness of IP or intellectual property around the world is very huge, especially for people who are working in research and in R&D, in companies, in universities. They have good knowledge about patent. So when they reach something new, immediately they file patent application to have Because if they with something like what you said, I want to have a patent for this mobile, but I still have an idea. And one of you told me that, okay, it is still an idea. Maybe I have the same idea and I reach it with this mobile before you. That's why when any inventor, any company, anyone reach to a new invention, the first thing he do it that they seek for patent protection before doing anything else, before even published in anywhere in the world. They have to seek for patent application. Again, because what, as I said, if you published, even if you yourself, so I'm Dina, if I am as Dina published my invention, which is COVID-19 vaccine, and then go to the patent office and apply for a patent, and it's new, it's invented, it's applicable, everything is there, it can be patented. But what patent office will do is that they will search for what is existing in the field, and they will find my own publication because I published it before seeking for patent application, before filing a patent application. And guess what? They will refuse my patent based on my publication, my own publication. So what about others' publication? So the first thing that inventors are doing on companies, large companies, R&D, research institute are doing around the world is that they are seeking, or they go first for patent application to protect themselves. Then maybe second day, 2 days after, you can publish your invention or your publication anyway. It's no matter. You already filed and you have right. It's called priority right. I'm the first one who files this. Second day, you can do whatever you want. Okay, so that's why the most recent, the most the newest inventions in the world are found in the patent database before the other databases or the other publications, unless the inventor don't know about the patent system he want to publish in the journal, or he are not very willing to have a patent application, so he just published his paper or his invention. So I recommend you to use this patent scope. It's very easy to use before doing R&D, before doing your research. The second thing I will recommend you is invest in R&D. So first, you have to search. You have to make sure that your invention or your idea is new. No one before you is doing this. And if someone is doing this, so you know and you can improve on what he or she did. So don't reinvent the wheel, just improve. After knowing what is there, you can invest in the R&D. But the most important thing is keep it confidential. So trust me, it's not always that someone else will steal your idea, will steal your work, will steal what you did. Sometimes, sometimes you give them your idea as a gift. So keep your invention, keep your search secret, confidential until you have the patent. If you have an idea about new pharmaceutical composition, don't run and go for pharmaceutical company and tell them, I have an idea of 1, 2, 3. Please help me to invest on research. It will not happen. Keep your invention secret and seek for a patent application. After you have a patent application, you can go for this company and say, okay, I have an invention and I file a patent under my name. Please help me to produce it. If you want to have a license, if you want to buy my invention, give me royalty. It is easy. And then after keeping your invention confidential, the next step, if you are doing another search before filing a patent application, because the research stage may last like 1 year, 2 years, 3 years. You are not, you will not know what is going on. So you have from time to time to do search to know what is going on during your research period. So maybe someone else reaches this idea before you, and he may publish it or file a patent application. So you will modify or you improve your research, your invention before filing a patent application. So after you finish your R&D, just do another quick novelty search before filing a patent application. You can do it by yourself, or again, you can ask for an expert who can use search strategy and give you more accurate results. And then the last thing is to draft a patent application. Our law firm is offering service who can help you to have search strategy and search for the invention in the field if you want, and also we can draft a patent application. Drafting a patent application is not easy. Patent application is completely different from the scientific publications. So you have to ask for an expert. But if you have your work done and properly done, the patent drafting will be easier than if you have only come with idea and go to the expert and okay, I want to draft a patent application for this idea. So try to finish your research before having or before going to the expert to file a patent application. Of course, the expert will help you in search for what is known in the art before doing research and after doing your research, and he or she may help you also in drafting patent application. Why drafting patent application is important? Why you think? Only because it have like the structure of a patent application is different from scientific research, or why you think it may be difficult to draft a patent application? Do you have an idea? Did you ever see a patent application or read it?
No.
Okay. I will tell you, because the language that is used in patent application is very like each word does matter. I'll give you an example. So you remember the example of I have a COVID-19 vaccine, which is consists of 1, 2, 3. And you told me, all of you told me that yes, it can be patented. And then I give you another example. I told you that I have a method of treatment of COVID-19. It consists of 1, 2, 3. Maybe my invention is the vaccine itself, but I don't know how to write the patent application, and I just write that it's method of treatment using this vaccine. And the vaccine itself is new and invented and applicable, so it can be protected. But when I wrote my patent application and I write its method of treatment, then it will be rejected, even if I did something already new and obvious and can be patented under patent system. Why? Because let me tell you that most of examiners around the world will not examine or will not search for your application if you are not write it in the right way. So when they see that it's method of treatment, without continue reading, they will reject it. Oh, sorry, it's method of treatment. Our law is not protecting method of treatment. So sorry, it's not patentable under patent law, and they reject. Most of patent offices are doing this. During my work in Egypt, I faced a lot of this. I faced a lot of inventors, like local inventors, Egyptian, who don't have someone to write a patent application for them. They drafted the patent application like this, method of treatment. But from my experience, I know that they may have something new, and they just don't want to pay for attorney to write to them. They don't have the knowledge of the law. So what I did is to have a meeting with these inventors and advise them. Please modify your patent application to be the product or the method itself. Don't mention the method of treatment. And this is usually happened in the pharmaceutical and in the biotechnology, because at the end of the day, all pharmaceutical compounds will use for treatment of one disease. And for biotechnology also, the antibodies, vaccines, blah, 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 are used for treatment. Or for preventing the infection with virus or bacteria. So it's very important to read about how to draft a patent application before filing your patent application, or ask for expert before filing your patent application. Because the language of your patent is really matter on what is the examiner, on the decision of the examiner, what is the examiner is going to do. Now you have also to have a patent strategy, because patent is not only to have a patent. Like the rationale is not only to have a patent. I am seeking for a patent application, not to go to someone and, okay, I have patent, my patent is granted, blah, blah, blah. Of course, granted patent will increase the value of the institute, of the university, of the faculty, whatever, but the most important when you file a patent application is to think how to get money from your patent, how to compensate the time and effort you and the money first you spend to reach to this patent. It's very, very important to have a patent strategy. Okay, you can do it by yourself, or again, you can ask about for expert. So, patent strategy, for example, is to decide, I want to protect my rights, or I want to protect my patent, to file my patent here only in UAE, or I want to protect it also outside the UAE. You have to take this decision. So where to file is very important to decide where to file your patent application. Again, from my experts, or from the firm experience with some universities, even here in UAE, some universities are seeking for protection for their patent, for example, in the USA. Okay, and it's good, it's really good, but they have to think first. If the invention is really important in USA, or important for the people in USA, they can give license in USA to the local companies to produce. For example, if you have, if your invention is about method of producing producing a plant, or method for making the plant resistant to insects. Okay, can you file your application in Japan? You know that Japan, there is no agriculture in Japan. So why you file your patent application there? It's not important for you. No one will be interested in your patent, although it's very important, it's amazing, but no one will be interested for your patent in Japan because they are not, they don't have agriculture. But if you are going for Egypt, for example, and you have like new species of cotton which is resistant to insect or whatever, and you go for Egypt to have file a patent application in Egypt, it's very important for you because you will find many people are interested in your patent. They want to use, yes, this method to have a cotton, to protect the cotton from the insects and whatever. So it's very important before filing, and also the dates. Like I found one of the university protect the dates in USA. Most of them don't know what is this. I have American friends and they tested when they came here, but they don't know it before. So maybe the American society are not interested in your invention. And it's not because your invention is not good or something. No, because you have to decide what to protect your invention. If you protect this invention here in UAE, it will be very important because many companies will seek for have a license from you to produce this bits, which is have something new from the bits that is found in the market. So before seeking for a patent application and before deciding where you want to file your patent application, you have to have a decision, you have to have a strategy. Why I want to protect my patent application in this country or in this country. So it's very, very important. And when it's very easy question, because as we said, you have to protect your patent once you reach to your invention. Of course, if you know that your patent will not be useful in Europe or in USA, but you want to have protection there, it's your decision. We can help you in this. But our mission is to give you an advice. And Mr. Fras, he is a financial person. So he knows the market and he advises inventors, your patent application will be important here or here and this type of stuff. For me, it's more logic. So, okay, this invention is not useful. In Japan, they are not using this. But if I invent some electronic device, I will seek for protection in Japan and for China, of course, because they are imitating many inventions. So it's very, very important to decide where to file a patent application. Is it possible to decide, is it possible to have a patent protection outside your country? Is it possible to have patent protection outside the UAE, in Japan? This is the patent granted from USA. It's how it's looked after granting. So can you have a patent protection outside your country? Sure. There is something, there is many methods to have protection outside your country, but the most important one is the International Patent Application, or what is called PCT, or Patent Cooperation Treaty. This treaty is the international route to file a patent application outside your country. There is 153 contracting countries. Can you see the blue color in this map? All the blue color are members of this invention. So whatever you are and you want to file patent application outside your country, you can seek for PCT to file your application, whatever you want around the world. You can choose between 153 countries. So it's one way to protect your patent application outside. There is another way, and it depends on how many countries you want to protect. So if you will seeking for protection in only one country like Canada, USA, Europe, I will advise you not to go through PCT, to go through another convention, which is Paris. It's more complicated than PCT, but it is cost effective if you are seeking for protection in one or two countries only. But if you want to have more than 2 countries, I would advise you to go through PCT because it will be easy and cost effective in this case. Now, of course, you know now the importance of patent system, but I will give you practical invention. This invention happened in Japan. So it was one farmer, small farmer, simple, maybe like, maybe he is not high educated, but he's very smart that he know about the patent system. He have a good knowledge. So this farmer, what he did, he invent this 3D packaging container. This package allows the food to stay fresh inside it for about 7 days, for about a week. 7 days, okay? And he thinks that he did something that is really an invention, and he seek for protection with international patent application, the PCT application that we talk about. And after he filed a patent application, he was very smart to choose a country that he want to have protection for his invention. And after having a patent, he entered into business agreement with farmers overseas. So he sold his inventions to others after protecting himself with PCT. And from the money he has from this agreements or license agreement, he make or he established his own company. And after this, he has a lot of license, more license with other companies around the world. So it is how it's done. It shouldn't be like, look what he invented, small invention. But there is a need for this invention. It is something new. He solved a problem in the art, that the fruits are not fresh for 7 days, it will be whatever. But he did this invention and he saved the vegetables and fruits for 7 days and it will be fresh. So it is how I want you to think when you are seeking for patent. Patent protection is very important, especially for universities and for the reputation of the universities. But so do it, go for this, but also think how you will gain money out of this. Look at this. Can you imagine how many patent applications Pfizer has? It's only one pharmaceutical company, and it have about okay, I can't only I am shocked with the number. Actually, it's about 58,000 patent applications till now for the pharmaceutical compositions, formulation, methods, like whatever you will think, you will find patent application with Pfizer. And this situation is not only for Pfizer, it is for all pharmaceutical companies, all large companies. I'm talking about pharmaceuticals the most because it's your field, but you will find the same in technology, in engineering companies, and so on. Okay. So it is our last slide. Our last slide, okay, but we are about to finish. So now we are talking about how universities can benefit from intellectual property rights. Look at this. I searched only about how many inventions or patent applications that the universities around the world file. Only PCT application. So the universities around the world file about more than 2 million patent application. 2 million PCT application. Okay, so it's very, very important for universities to have a patent application. It will affect on the reputation of the universities. That's why universities around the world are seeking for patent application. And here, I just want to show you which one is the ranking of the countries. So China is the first in the world to file universities. It's about universities, okay? So universities in China is the first in the world, and China is only the university in China file about 1 million. What? How can I know it?
1.5 million applicants.
1.5
million. Can you imagine?
It's only in China, and United States is the second ranking, and then PCT application. Here you file that countries are ranked with how many applications they. For the applicant, you can find that University of California is the first in the world to file patent applications. It's about 34,000 patent applications for University of California only. Now I will tell you why universities around the world are seeking for patent protection. So first, most companies, pharmaceutical or whatever, before they are starting to work on something, the first thing they are doing is not only to search that this thing is or this product will be new or not, like what we said, but they are searching that if this invention is protected by patent or not. Because if it's protected by patent and they are working on this, they will be infringers. They will infringe someone else's rights. So they are very careful before they are doing search to search first. Is this what I'm going to work is patented for someone else or not? You as a university don't have to think about it. Why? Because you have exceptions for academic research. So if the invention is protected by any company, whatever, you can still do your research and use it for research only. Okay, you cannot produce or sell, of course, because you will infringe others, but you can use this invention to do academic research and improve on it. Universities are doing this, are seeking for patent application in order to enter license agreement with others, with business, which is called technology transfer. Technology transfer is very, very important for university. So one thing happened. First, universities are rich in invention, new inventions. They seek for patent protection. They have the patent, and then they go to business and ask them to utilize this patent to buy this patent from them and to manufacture. Okay, this is one strategy. The other strategy is that, especially in University of California, University of Chicago, whatever universities in general in USA, they are doing the opposite. So they are going, for example, to a company. What is the problem you need? What is the problem you face in the current product? And they telling them, we have a problem in this product. We need, this pharmaceutical composition is not stable. We need to make an improvement for this pharmaceutical composition to be more stable. So universities go to business and ask them what problems they have. And then they are doing the research inside the universities. The R&D is done inside the universities using university laboratories. And they have an agreement between the university and the business who, after reaching to this invention, the agreement will manage the percentage of the profit and blah, blah, blah. So universities outside, and it starts to be also here and in Egypt and many countries. Knowledge transfer starts to be in most universities now. So it's very important because students will learn from business. They will know what is going out there, what is the practical. You will have the practical experience from the business, from the companies, and at the same time, the business will benefit. And at the end of the day, both business and university will benefit from the profit they will get from this. So that's why universities are around the world are seeking for patent application to get money out of this. Some universities are seeking for patent application only for the reputation of the university itself. So our university have 50 granted patents. Our university filed 200 patent applications and so on, and they write it on the most universities around the world. They write something about intellectual property, how many patents they filed or how many patents they granted, and so on. And sometimes one university also in UAE is filed in their website, they have the patent applications filed by its students. So patent application is very important for university because they are free to use any patent application, any information patent application, even if it's granted by patent office. They can enter license agreement, they can have technology transfer, they can have patent portfolio, and they can have also monetization. Monetization is about converting the intangible assets to money. So converting the patent or assess the value of patent and get money out of it. Okay. I'm not sure if some universities are doing this or not, but most universities are doing the previous. It will be very rare in universities, to be honest. But license agreement, knowledge transfer, patent portfolio for the universities is very, very important. So as universities get benefit from intellectual property and patent, they have to have strategy and policies for the IPR, for the intellectual property rights. Why it's important to have a strategy and policy for universities? Because published patents support the economy and researchers' reputation. It is secured. It's secured. The IB, secured IB attract partners. I go through your website and I see that you have some partner with the DHA and other partners. So intellectual property will be very important for you to secure yourself. When you enter in partnership with others, you have to manage the cooperation and sharing of profits from successful exploitation. It means that we file a patent, the share of your university is 50% and the partner 50% or whatever agreed between you. So you have to manage the sharing of profit from the successful exploitation of your patent. And most universities are doing this actually. Also having strategy and policy will create an environment that support and encourage the innovation and the development. I am doing R&D and I know I will get benefit from it, so I have more encouraged to reach it with a new invention. Bringing research results to the next stage of development. It means that you have research, you have result, and you want to go next step to develop your result or to make your result come into product, real product. So you enter into license agreement with someone who can manufacture or who can produce your invention. Encourage researchers to consider the possible opportunities for exploiting an invention so as the increasing of the potential flow of the benefits to society. So it's not only again about profit, it's not only again to have money, but it will also benefit the society. If you reach to a new invention which benefit to society, you have to have IP right, you have to protect it by IP system, by patent system, in order to enter agreement with others who will produce new invention, because most inventors don't have money to produce their products and make it real product. They only invent. They don't have enough money. So they want to protect their IP and then seek for someone, for company, for the party who can produce this invention. The inventor will benefit from the money he will get, and the society will benefit also from this new invention, new treatment, whatever. So this is the last slide. Want to cooperate with your faculty, so are offering 20% discount for the student and alumni professors from your college in all IP related research, who can help you in research, draft, filing, patent in here inside UAE and outside in whatever countries you have. We have offices outside UAE in many countries, and we also have partners around the world. We can help you to make a deposition for copyright for the book or articles you are publishing. You can deposit this or the file copyright protection with the Ministry of Economy. Here we can help you in doing this. Trademark filing and industrial design may be not very related to you, but if you want to file or have a trademark, your college trademark or whatever, or if you enter with a partnership and you have a product which has trademark, we can help you in protecting the trademark and the design. All infringement and IP cases, any legal consultation, we are giving free legal consultation for IP, and also can help you to have IP strategy and policy. So it is the last slide I have. Now I finished my presentation. Thank you all for listening and for your time. I think we can have now questions if you need.
Thank you so much, Mrs. Dina. Thank you for the very enlightful presentation. It was very interesting and it was very useful. Thank you so much. And now, if you wouldn't mind, we can start our Q&A session. Anyone who has any question can please type it in the chat box. I guess we already have two questions, one from Zainab. She's asking, is there something like international patent or only for each country?
Okay.
I guess she said later that it's answered. I'm not sure.
No, it's not answered.
Oh, okay.
Okay, sorry.
Yes, it's not answered.
Okay. Here we said that we have international patent application. What does it mean? It means that this convention and any convention around the world will help you to file your patent outside your country. It's not to have, there is nothing called international patent. So your patent can be granted in USA but refused in Europe. It can be granted in Emirates but refused in other countries, in Egypt or in USA. So there is nothing called international patent. International patent means that you file one patent application, and when it is accepted by the patent office, you will have protection around the world. There is nothing called this, nothing called international patent. But there is something called international patent application. Applications means that you can file your patent in the countries, and each country will examine your patent and decide to grant or to refuse your patent. So it depends on the decision of each patent office in each country. So it's the first question.
Yes, I guess that's very well answered.
Yes,
Okay,
thank
next
you.
we have Dr. Ammar. He's asking, could you please show us how you search based upon university?
How what? Sorry?
Could you please show us how you search based up on universities?
Okay.
Yes, you mentioned something about.
I'll share with you now. So our database is patent scope, and you can find it here. It is Weibo.
Mrs. Dina, are you sharing a screen? Because we can only see the PowerPoint screen.
Oh, sorry. Now you can see, yes?
Not yet.
Not yet. Okay. So now you can see, we still not.
Yes.
Okay.
The web. Yeah.
So what I write on Google is patent scope only. Okay. It's with Weibo. This is the look of Weibo Intellectual Property Organization. Access to patent scope database. And this is what you will find. Okay. This one is called simple search. If you click here, you can choose between this called text, the number, something called classification, but it's only for experts because it's complicated. So just ignore this, but you can search in full text or the front page. Front page is the first page of the patent application. It has the name of applicant, the inventors, the title, and the abstract, and the number of the patent application. So it is simple search, okay? If you click here, I will refer to it with the field combination. So this is the slide of what I shared with you before. And here you can search. I like this one because I want to search. Oh, there is Spanish, Russian, Korean, Swedish, whatever you want to search about. Let us search about applicant name. What applicant we can use, California. Or let us with one pharmaceutical company, Sanofi, for example. And English. Let's choose English abstract, for example. Insulin. Here you can choose between and. Okay. So we have about 900 results. Patent application filed only by Sanofi for insulin only. Search. And here you find all the documents. Okay, I will open one with you. Here you can find the code of the country. So it's this application from Australia. This is Mexico. This is Indian. I want to share this because this one is PCT application. Okay. When you open the patent application, that's what you are going to see. You see the abstract. I think it will not be useful because it's in French, but anyway, yeah. I search for another one in English. It's better to have one in English. Okay. So Sanofi is a French company, so let it be Pfizer because we'll find most application in French. Pfizer filed about 300 patent application for insulin. Here is the code of the country again, it's Europe. Okay, let's open this US application. Treatment of insulin resistant synonyms. I told you that method of treatment is not protected. So method of treatment is not protected in most countries around the world. They are not protected here in UAE, they are not protected in Egypt, they are not protected in Europe and in India and in most countries. They exclude method of treatment from protected or from having patent by patent system. But the only, like, there is few exceptions, and US is grant patent for method of treatment. So few countries few countries allow patent for method of treatment like US. That's why when Pfizer seek for a method of treatment, it go to US to have their patent. So here you can find all the documents with this patent application. Okay, here you can find the abstract, the claims, you can open, like you have 29 page of applications. I am searching for PCT application because I want you to see what is patent application look like. Okay, it is the publication. So I will open this with you, but I just want to explain something. Here you can see International Application Status Report. It has all the information of this application. The abstract, the title, and the inventors. What I want to say is that the inventors should be mentioned in any application. So if you are inventor for a patent, your name has to be mentioned in the patent application, even if you sell your guide, all your guides to company, your name should be there. And this is how the patent application look like. It is the first page, is PCT application. It is a number, PCT. Again, here is the applicant, the inventor, the title, some drawing, and abstract. Then the patent application will contain all information you need to know about this invention. It will start with the background of the invention, what is already exists. Because as I told you, anyone who wants to file a patent application, he will do search first. And this is international pharmaceutical company. So what they did is to search for what is already exists, and they write it in the patent application. They have to write what is exist and what the modification they did. So what is exist in the market, what is the deficiency, or what is the problem, and what they actually did to solve this problem. And of course, the experiments that show that the medicine or whatever of the method is already work. So here is the background. And then it has some figures, and here's the illustration of the figures they have, of the drawing they have. And that's it. All of this is the illustration, brief illustration of their invention. And here it is what is called claims. Claims is what exactly this company or this applicant means the owner of the invention. What exactly this applicant or the owner seek for the protection. So here, this part of the invention should be given by an expert, because as I told you, this is every word in this have a meaning, make a big difference. Like here, for example, you see comprising and you think, okay, comprising is normal word. But let me tell you that Pfizer using comprising because it has a big meaning. They didn't use consist of, they didn't use include, they used comprise because they want something. What is this? Comprise means that this invention comprise 1, 2, 3, but maybe it comprises something else that is not written here. So the language of the claims is a little bit complicated, but anyway, it is how the claims of the invention look like. Before doing, and this is the figures, which is the sequences, the amino acid and the nucleic acid sequence of this application. But what is important for you when you are doing this research is the description of the patent application. What is the background, what they did, the deficiency in the period art or the deficiency in the field, and how they solve this problem. So it is how to search for patent scopes. So any other questions? Did I answer your question, please? You need more clarification for something?
Hello.
Hi.
Yes. Hello.
Yes, yes.
Yes,
Hello,
good
Dr.
afternoon.
Ramadan.
Yes, good afternoon.
Good afternoon.
Yes, I'm very happy to be with you today. And just I have a simple question. It's about the validity of the patent period, and the fees need to be paid by the inventor or the what they call it patent holders. For how long, and what's the conditions could be valid based on that the inventor need to apply for to extend the validity of the patent certificate. Thank you very much. Thank you.
Okay, thank you. So just to make sure that I understand your question, you are talking about the fees not of filing a patent application, but the annual fees to maintain your patent, yes?
No, sometimes if we have a patent,
yes,
it could be 20 years plus minus.
Okay.
And I want to extend my as an inventor, I need to extend the validity period. How much is there any fees need to be paid? And if I guarantee the patent validity, what is the interval usually paid? Usually the inventor need to be paid 3 years, 7 years, 10 years, or no need for that, according to your experience.
Okay. Okay. The minimum period of protecting patent is 20 years. This minimum period is mentioned in TRIPS agreement. Okay, it's international agreement which manage or organize all intellectual property rights. So this agreement said that the minimum protection period for the patent is 20 years. That means that all contracting countries, which is almost all the countries around the world, or even all the countries that you will seek for the protection in these countries, they are all contracting parties of TRIPS agreement, and it says that it's 20 years. So most countries over 20 years of protection in patent. Also, most countries offer only 20 years. They don't extend the period of the protection by patent system. Why? Because what I said, because they want only 20 years of protection, and after this 20 years, the invention, anyone can use this invention. The local companies can use this invention and manufacture it. So most countries provide only 20 years. They are not provide any extensions, like in UAE, in Egypt, and almost most countries. But now, some countries, I think, like USA, they are discussing. It's still under discussion. Okay, they want to extend this period, which is 20 years by 5 years. So they want that patent protection to be 25 years, especially for pharmaceutical companies. Why? Because as I told you, once as a pharmaceutical company, once any inventor around the world reach to the new invention, directly he goes for patent protection for this invention. So pharmaceutical companies, once they reach the invention and they know that it will work, they file a patent application. And then they not manufacture this medicine, of course. Why? Because they have to have license from the Ministry of Health. They have to do 3 years like first, second, third, they have to make sure that this medicine is safe when it will be administered by patient. So they still have to do some research, and they will have some data regarding the safety and whatever data that is required to have license from the Ministry of Health in each country, of FDA in USA. So it will take time, and this time is deducted from the 20 years. So they will not make useful of the whole 20 years because they file an application, they spend some few years, maybe 1 to 3 years until they have license to make the medicine in the market. So they lose time. That's why in USA they are still discussing to extend this time period 5 years for the pharmaceutical companies because they want to compensate the pharmaceutical companies on the time they have until they have the approval from the Ministry of Health or FDA. So, but I think it's still under discussion here. So till now, it's not allowed to extend the time of protection. So, any other questions? Any more clarification or something?
Actually, yes.
In the chat box, Zainab, if you can please ask your question, because it says, does having a patent application necessary means that this inventor has
I
the
mean, in the
patent?
search here, when we see that this company or this university is having a patent application, does it necessary that they have the patent for the product itself? They finished it, or it is just the application?
It is just application. Okay. It doesn't mean that this application can be rejected from the patent office or can be accepted. I want to share with you something. That's why. Okay, I don't know why this application can be open.
Girls, meanwhile, while Mrs. Dina is preparing her answer, if anyone else needs any question, please try to write it in the chat box. We want to wrap up the meeting.
You don't have any more questions, yes?
Actually, I have some questions, but I just waited maybe as others will start. If I want to ask the first one, actually, regarding the drug repositioning, because we are pharmacists, so maybe you have already existing drug at the market, and then we discover a new application for this drug. Like, for example, this drug is used for generally, let's say, hypertension, and then I will discover that it is a great a drug for as anti-cancer, for example. So maybe it's a new idea. Maybe I've discovered a mechanism, and a new mechanism. That's why this drug may be used for treatment of cancer. So can we apply this one as a patent or not? Thank you. This is the first question.
Okay, I will answer this question first and then share with you what. So what you are talking about is a new use of a non-pharmaceutical composition. Yes. Or that you discover the mechanism of the composition. Actually, new use of non-pharmaceutical composition is considered as a method of treatment in some countries, because the pharmaceutical compound is already known. So, but it was used for treatment of one disease, and you use it for treatment of another disease. Yes. So some countries consider it as second use, and they are not grant patent for this. So this invention, but again, it depends on the law of each country. So if you have this invention, I will advise you not to file a patent application in Egypt or in most Gulf region, because here in UAE, in Saudi, in Oman, in most countries, they are not protecting the method of treatment and the second use. But I will advise you, if it's really novel and inventive and can be applicable, of course, you can seek for a patent protection in Europe or USA, because they allow the protection of the second use. But of course, the claim should be written in, or the patent application should be written in a specific way in order to be accepted by these offices. But that's why we can advise you. We are not going to tell you, no, you cannot have a patent, but we are honest with you. You cannot have a patent here in UAE or in Gulf, most Gulf countries, or in Egypt, in India, for example, also, but you can have a patent in Europe or in USA. So did I answer your question?
Yeah, perfect. Thank you.
Okay. The previous question was about the application of patent, and does it mean that it is granted or not? Yes.
Yeah.
Yes.
So look at this. EB is European. So this one is European patent. And look at this. It's P. P means it is patented. So this application was patented from the European office. Okay. So you will find here, it is the code of the country. And it is written here also, European patent specification, but I'm talking about the numbers now. So it is the European office, and here is the number of the application, and P indicates that this patent was granted, or it's issued. But if you find here, instead of P, if you find A, it means that this patent is filed only, and it is not granted here. So it is still under examination, or it was issued, but it's not patent.
Great, thank you. Very clear now.
If anyone is having any questions.
Yeah, I have another question, if you don't mind. We know that, for example, the BI or the owner of the idea will be the one who will make application for the patent. So what about the other group in the team? So for example, they will all together work to make this idea, but he is the owner of the idea. This is argue actually between some of colleagues. Some say that all the team should be included in the patent. Some will say, no, only the owner of the idea, because others will be just doing the idea. So what's about the answer to this question? Thank you.
Thank you. like it depends. In my opinion, like there is no rule, by the way, okay? But in my opinion, that my invention will not come into true or not be achieved without the help of others. So if I understand this well, I will talk with you from my experience. So I worked in the pharmaceutical, biotechnology, and microbiology field. I worked in the three fields. So sometimes you see, I see the inventions, which is chemical compound, for example, to treat cancer, is combined with antibody. So we know that the chemical treatment will kill all the cells for the cancer, the normal cell and the carcinogenic cell. But when they did this combination, the pharmaceutical compound with the antibody makes this compound only target the cancer cell and kill it. This invention cannot be done by only one inventor. It should be done by many. One is specialized, or more than one, is specialized in chemical compounds, pharmaceutical, and one or more inventors specialized in antibodies. So they work together and they come with the idea, with the invention, sorry. In this case, in my opinion, the name of inventors should be, all inventors should be mentioned in the patent application as an inventors and as a patent holder or applicant. Okay, and then there should be license or agreement between these inventors that manage the percentage of the profit that they will have from this patent application. So I did the major work in this patent application. I will take 50%, and the 4-5 other inventors will take the other 50%. Why? Because I did the major. Maybe we have, like, just after I finish with you, I will have an appointment with the inventor, with the laboratory she is working in. The laboratory will take 70% and she will take 30%. So it depends on the negotiation or the agreement between them. But in my opinion, especially in this case, which I mentioned, they should all get in as inventors and applicants. And then there is another agreement that manage the percentage. Some other cases that I already have the whole idea. So I know that when I use this molecule with this molecule, and I know, for example, the example I give for risperidone with compound A. I know that when I combine risperidone with compound A, I will reach a good result. And I just want someone with me that help me, so I have the whole idea. It's my own, and I know that it will work. So, but only for like producing in laboratory, I need the help of others. So in this case, my suggestion only also. So it's only my opinion. It's not, there is no rule as I thought. But my suggestion that all the people working on this invention may be, or it's better to be mentioned as inventors, but the applicant or the right holder can be the one who gets with this idea, the whole idea. Okay, so it depends. In my opinion, it is moral right that everyone working this invention can be better to be written as inventor, but at the end of the day, the applicant or the owner, the right holder, the one who will get money from this application, it should be determined on the contribution of the agreement. So if I have the whole idea, as I said, I can be the only applicant or the right holder, the only right holder. And others can be written as inventor because they have moral rights. They spent also effort and so on. So they can be written as moral right. or as I said, that they can all work together and have agreement between them who will own the rights and if it's going to be shared or not, and the percentage of that sharing.
Thank you. Any other question, guys? So I think I will have and last one. You know that when you make application, I usually have a lot of questions. When you have application or something, we as you said, unfortunately we don't have international. Although even if this is drug and this drug is will be used in all the countries, but unfortunately we don't have something international, as you mentioned. So when I want to apply for my patent in, for example, here in UAE, I have to apply it also in USA, and I have to apply it in Korea, I have to apply in Japan, I have to, and so on. So this is just, it's expensive. So some of so inventors at this case, they would just make it in one country or two country maximum because of the money. So do you know something like agency which can help in something like that? If I have a patent and I wanted to file it in more than one country, so we can we can make they can help, and later if there is any financial issue or something or any benefit from this patent they can share. Do we have something like that? Thank you. Last question.
Okay, thank you for your question. I like it. Okay. Actually, there is different strategy you can do. Like first, before working on this invention, you can go for some, like what I said, technology transfer for one company, and I want to work on blah blah blah. Let us share the benefit, or not, maybe not company, maybe DHA or whatever organization, just to do an agreement before doing this research that I will do the research, but I don't have enough money to fight in other countries. So we will share benefits. I will do the whole work. So I will have 50% and you 50% or whatever you agreed in. So it's one strategy. Another strategy that also I have invention and I have invented in our law firm. He came, and what he did is he asked our for our service in searching and filing a patent application, and to help him in this. And when we finished, he asked us to file a BCT application. He don't want to file here in UAE, and we advised him to do so also. So we advised him to have a BCT application, because after BCT he has 30 months, 30 months. So it's about 2.5 years in order to decide which country he want to seek for patent protection. So he don't have enough money to fight in other countries, although his invention was really good. So we asked him, or we advised him to file BCT, and file BCT is also costly, but less costly than file in many countries. So we asked him to file a BCT application, and after 30 months, he is going to meet, I think this month or next month, he is going to meet a company that may be interested in his invention. So first, he protected himself before going to this company and disclose for his invention. Because who knows, maybe the other country will just, I am inventors and I go to one company, I have an invention, I did 1, 2, 3, and I disclose or explain everything about my invention in order to have agreement with this company. Sometimes the company may steal my rights. They will take my idea and manufacture it. Who will prove that I am the one who reached with this idea, or I have right with this idea? So we advise him to first file BCT application and then negotiate with this company. And he did so. I think it may be he may have the deal. And when he has this agreement, the company will make an agreement with him and file in other countries. It is one thing that you can do. Another thing is that he also after he has a DCT application, he has more than 2 years and a half to study the market, to see if his invention will really, the market really need his invention or not. So if the market is really need his invention, he will try a patent. If not, at least he don't lose a lot of money in filing in other countries. He just lose a few amounts to its risk or little risk to this. So he did this, and I think he is successful, really successful, because his item is really amazing. And in some countries like in Egypt, I was working in the Academy of Scientific Extraction Technology. They have some department which give money for the inventors to like to manufacture or produce their inventions. So it depends. I don't know if there is something here or not, to be honest, but I think you may find someone who will give you money. Institutions, there are a lot of institutions for innovation, which encourage innovation and inventions. So you may find someone who can give you money. But first, you have to protect yourself, and you have to protect, even by patent, even if not by patent application, you have to protect yourself by entering into a license or contract before doing anything, or disclose or explain your invention.
Thank you so much. It's clear. Thank you so much. Any other question, guys? Yes, Ms. Yasmin, please.
Yes, I guess that's all. So thank you so much, Mrs. Dina, for your very insightful presentation. It was very comprehensive and it was very clear. Thank you so much for giving us some of your time. You and Mr. Firas, and also the Noura Al-Mazmi Advocate Center, thank you so much. We really appreciate you being here with us today, and we would look forward, inshallah, to further meetings. Thank you so much, Dr. Hanan, for arranging this very useful webinar. And I would like only to remind the students, please don't forget to fill up the survey in order to get your certificate of attendance, also faculty members. And that's it. Thank you so much, Mrs. Dina.
And thank you. It was my pleasure to be with you and with your colleagues. Thank you for arranging this. Thank you, Dr. Hanan. Thank you for everything.
Thank you so much. Okay, I'll keep.
Thank you so much for your great efforts. Thank you, Ms. Dina and Mr. Firas. Thank you so much for your information and your comprehensive work. Thank you so much.
Thank you so much.
So I'll keep.
Thank you, my students as well.
Open for some time until girls finish up the survey, and the link will be there in the chat box. And anyone who's done is free to leave.
Thank you, Dr. Yasmin, as well. Thank you so much. Thank you for all attending. Thank you so much.
Okay, so I see you.
Inshallah, see you. Inshallah, yani we will meet up. Inshallah, on the future event. Inshallah, Ms. Dina. Thank you so much.
Inshallah, inshallah. Thank you, and bye. Thank you, everyone.
Thank you so much. Please just answer the survey so you can get the certificate. Thank you so much.